Hey there, GoPo students. Shefferly here. Yeah, I got my Cal Poly dad shirt on, right? Because that's where Tristan's going to go. So super proud that Tristan's going to carry on the tradition at the best school in the history of the United States. Way to go, Tristan. All right, today I'm going to start reviewing Unit 2 for the AP test coming up on May 11th, ladies and gentlemen. So 12 days from now. I'll do a Unit 2 review with court cases because this is where most of the court cases are. Which is civil liberty, civil rights. I'm also going to do a Unit 5 Congress and the President review, and I'm also going to do a Unit 6 Judicial Branch Bureaucracy review. And then lastly, I'm going to post a short video walking you through the steps of what to expect on the day of the AP test, what you should have, and what you should do beforehand. I did a webcast last night, and they said you need to log in about 30 minutes before the test because there's some security measures you have to go through, but I'll walk you through all that in a separate video. So I'm going to start off with a screen share here, ladies and gentlemen, and I want you to have this packet open right here. This is the final review packet, which I have already posted again on Google Classroom, and this is our Unit 2 Civil Liberties and Civil Rights. This is Unit 6 for the College Board, but I do things in a different order. Okay, so what I want to do is go through all of these, and I should cover most of these review questions as we go through this, and then I want to cover these primary documents and these court cases right here. In fact, I need to open up one of my primary documents there before I get going. So today is going to be really, really heavy on the court cases because civil liberties, civil rights, that's where the vast majority of our court cases come from, ladies and gentlemen, okay? So here we go. All right, so I have this screen shared up here. Here's a letter from Birmingham Jail, but I want to come back to this, and let's start off with review of civil rights, okay? I doubt affirmative action is going to be on there, so I'm not even going to cover that. The 15th Amendment, remember, is a franchise amendment. It bars racial barriers to voting. So a state cannot deny somebody the right to vote based off race. This was passed after the Civil War, the 13th, 14th, and 15th Amendment. 13th Amendment made slavery illegal. The 14th Amendment, remember, where the states cannot deny people equal protection under the law or due process under the law. And so I want to review this. Remember the difference between civil liberties and civil rights, okay? Remember, civil liberties are your protections against governments, both local, state, and federal, right? So for example, we could say that government shutting down beaches right now in public parks and not letting you go outside your house would be a violation of your civil liberties because that's the government doing something to you. Civil rights are your protections against other individuals and private entities, right? So if a business says, I'm not going to hire you because of your gender or your race or your religion, that's a violation of your civil rights because that's one private entity to another, versus civil liberties are your protections against the government doing things like freedom of religion, freedom of the press, freedom to assemble, the right to own a gun. Those are your civil liberties, okay? So, so civil rights, remember the Civil Rights Act of 1964? This could be a document that you might have to use in your argumentative essay as a primary source. The Civil Rights Act, we're mostly concerned, if you remember this from your notes, Title II and Title VII of the Civil Rights Act, okay? Title II, which is the justification for not allowing racial discrimination in places open to public accommodation. So why can a hotel not be allowed to say, I'm not gonna let somebody stay there because of their race? And where does Congress get the ability to enforce that? Well, if you remember, Title II says it deals with commerce, interstate commerce. And so Title II of the Civil Rights Act says that Congress, through the Commerce Clause, has the ability to regulate interstate commerce. And one of the regulations they put in place is any places open to public accommodation cannot practice racial or gender discrimination. And so if a hotel, which is open to interstate travelers, they cannot ban somebody from staying there because of their race, because they'd be violating Title II of the Civil Rights Act, okay? And then Title VII of the Civil Rights Act deals with gender discrimination in hiring of people. So Title VII bars gender discrimination in hiring practices. And then Title IX, if you remember that one, Title IX talked about equal opportunities in publicly funded educational institutions. So when it comes to gender. And so Title IX is the reason that if you receive any public funding at all, local, state, or federal, you are subject to Title IX, which says you have to have equal opportunities for both genders in educational and non-educational opportunities like sports and extracurricular activities and things like that. Okay. Now, de facto, de jure, I doubt that'll be on there. Eminent domain, you should remember what that is. Equal protection clause. So if we remember this, ladies and gentlemen, the 14th Amendment says the states cannot deny somebody equal protection under the law or due process under the law. And so remember, the Equal Protection Clause is what incorporates your civil rights to the states. So I would draw a line from the Equal Protection Clause over to this thing called the Incorporation Doctrine and back over to the 14th Amendment. Because what is the Incorporation Doctrine? The Incorporation Doctrine is applying the Bill of Rights to the states. Remember, the Bill of Rights originally only applied to the federal government, not the state government. So when we say that you have the right to freedom of religion, when we say that you have the right to own a gun, when we say that you have the right to an attorney from the First, Second, and Sixth Amendment, that only applied to the federal government's restrictions. The state government, remember, could deny you the right to freedom of religion or the right to own a gun or the right to not have an attorney when they put you in jail, because the Bill of Rights, the first 10 amendments, had not been incorporated yet through the 14th Amendment. But remember, the 14th Amendment says that states cannot deny people equal protection under the law, and states cannot deny people due process under the law. So if the government is going to take away your life, liberty, or freedom, of which they can, they have to follow due process of law. If the states are going to pass a law, the states have to give everybody equal protection under that law. So the Equal Protection Clause incorporates your civil rights through the 14th Amendment. The Due Process Clause of the 14th Amendment incorporates your civil liberties to the states. So we're going to cover all these court cases and just keep coming back to that. The Incorporation Doctrine is where we apply the Bill of Rights to the states. And then there's a couple different kinds. There's selective incorporation, which means on a case-by-case basis, which is how we've done it. And then there's total incorporation, which is applying all the Bill of Rights at once. Okay? So Equal Protection Clause incorporates your civil rights. Due Process Clause incorporates your civil liberties. Okay? So remember, once the 15th Amendment was passed, the states that had historically been discriminated against or had used discriminatory voting practices tried to find loopholes in the 15th Amendment by making people do literacy tests, by passing poll taxes, by doing the grandfather clause. And so these were loopholes that states in the South put in place to circumvent the 15th Amendment. And they said, we're not denying people the right to vote based off race. They didn't pass the literacy test. They couldn't pay the poll tax. Their grandfather didn't vote, so they don't get to vote. And so these were the circumvention of that. Now, if you remember, how did we eventually end these loopholes that were put in place by some southern states to get around the 15th Amendment? And remember, that was the Voting Rights Act. Okay, so the Voting Rights Act, which was passed in 1965, I believe, closed these loopholes of literacy test, poll taxes actually ended with the 24th Amendment, I believe, and then the grandfather clause. All right. So the letter from Birmingham jail, I recommend you go read that again from the review that we had. I'm going to come back up to this. So remember, the letter from Birmingham jail was written by Martin Luther King, of course, and where he was talking about how civil disobedience is necessary to sometimes break unjust laws, and people have a moral obligation to not follow unjust laws. Okay, and he was very critical of white clergy in the South that didn't denounce these policies that were happening. And so this was one of the key things that led to the passage of the Civil Rights Act. Okay. All right. So coming back to this, screen shares there. Okay. So civil rights, I went through those pretty fast. You had a whole year of civil rights when you took U.S. history. So hopefully that stuff remains. What you didn't have was civil liberties. So let's go through these. And I'm going to try and go to the court case as these come up. So clear and present danger doctrine. Okay. Well, let's start off with Bill of Attainder just says the government can't issue a punishment without giving you the trial first. Okay, so the government can't arrest you and say we give you 6 years in jail. They have to give you the right to a trial first. Clear and present danger doctrine. Let's see if any of you just remember what was the clear and present danger doctrine. What court case did that come from? Okay, well, let's come up here and let's see if I can find it. Which one do I have up here? Bam, bam. Okay, so clear and present danger doctrine deals with First Amendment freedom of speech. Okay, if you remember, Schenck was passing out flyers to encourage draft eligible or draft age men not to go into the draft, and he called them involuntary conscription. He thought that was unconstitutional, and so he was arrested for that, and he appealed, and he said his First Amendment rights to freedom of speech were being violated, and so the court unanimously 9-0 ruled in favor of the government because they said that speech that inhibits the U.S. government from executing its powers is not protected under the First Amendment. Okay, so while freedom of speech is protected under the First Amendment, not all speech is protected. And this is one of the first cases we look at where we say your civil liberties are not absolute. Speech is protected, but it's not absolute. The government can restrict certain forms of speech. Okay, and then this is where it comes to clear and present danger, right? So speech that presents a clear and present danger isn't protected, ladies and gentlemen, right? So there we go, Schenck versus U.S. All right. Now let's come back to the next one up here. Double jeopardy, that's from the Fifth Amendment. And you have to remember these amendments, clear and present danger doctrine concerns free speech from the First Amendment. Double jeopardy is in the Fifth Amendment, meaning you can't be tried for the same crime twice. Due process clause is also in the Fifth Amendment. It's also found in the 14th Amendment. And like I said, the due process clause is what we use to say that the government can take away your freedom. They can put you in jail. The government can take away your property. The government can take away your life. They can do all those things, but they have to follow due process of law. Okay, if the government takes away your life, liberty, or property without due process of law, then your civil liberties have been violated. And that's what a lot of these cases are about, is the government has to follow these concepts before they can take away your life, liberty, property. Okay, now the Establishment Clause. Again, try to remember, what amendment is that from? And what is it dealing with? What provision of the First Amendment? Right, so the Establishment Clause is dealing with freedom of religion in the First Amendment. What court case do you remember us dealing with the Establishment Clause? Let's see if I should have it open up here. I'm going to go right to it. Okay, here we go. So Engel v. Vital. Okay, Engel v. Vital. Now there are multiple cases that deal with this, but this is the court case that incorporated the First Amendment's freedom of religion to the states. Remember, a court incorporation is applying the Bill of Rights to the states. And so remember, you should have this all filled out, where we had a school district that had a policy of starting each day with a salute that referenced God, and some schools were required, students were not required to say the salute, but they did start it with each day. And some students claimed that that was a prayer being led by a school, which violated the Establishment Clause. And the court ruled 6-1 in favor of Engel that prayer at a school was a violation of the Establishment Clause, because using school administrators or teachers to lead or enforce prayer was the equivalent of government establishing an official religion. And so this did violate the Establishment Clause, because it says government officials could not sponsor religion on their way. So remember, this came out to, this is a part of the Lemon test, where if a law specifically promoted one religion over another, inhibited one religion over another, or promoted religion in general, or it had excessive government entanglement with religion, then it was a violation of the First Amendment's Establishment Clause. So remember, the law had to be, and also in the Lemon test, is that if a law was secular in nature, that the law was not a violation of the Establishment Clause. So for example, a state government giving public transportation fees to schools, to students going to private religious schools, that's not a violation of the Establishment Clause, because transportation is secular in nature. And those students would have got transportation paid for if they went to a public school. And so remember that term, secular. If it's a secular law and it doesn't promote one religion over another, inhibit a religion over another, or cause excessive government entanglement, then it's not a violation of the Establishment Clause. So this was the case which incorporated the Establishment Clause to the states from the 14th Amendment's due process clause. Okay. The exclusionary rule, that comes from the Fourth Amendment, because remember the Fourth Amendment says that the government cannot have any unreasonable searches and seizures. And the exclusionary rule says if they do an unreasonable search or seizure and they find evidence during that unreasonable search or seizure, then that evidence is thrown out and the government can't use it in a court of law. I don't believe that's one of the required court cases this year. It's not, but it comes from the case Mapp versus Ohio. You're not going to have to know that for this year, okay? The free exercise clause is also dealing with the First Amendment, freedom of religion. But remember, the Establishment Clause says that the government cannot establish an official religion of the United States or promote religion in general or promote one religion over another. The free exercise clause is dealing with your practice of your religion. Can the government interfere with your practice of your religion from the First Amendment, okay? And who can remember the court case that dealt with incorporating the free exercise clause of the First Amendment, okay? You remember? It dealt with the Amish and sending their kids to school. Anybody remember? That's right, it is. I'm trying to find it up here because I have them all open. It is Wisconsin versus Yoder, okay? If you remember the basic facts of the Wisconsin versus Yoder case, and I think you should know all these court cases because you can use these as evidence in an argumentative essay, right? When you write the argumentative essay, remember they're going to give you 3 foundational documents you can use, and then you can use other evidence from your course of study to support your argument. These court cases are going to be great ways that you can support your argumentative essay if it calls for it. So remember the Wisconsin versus Yoder, this incorporated the free exercise clause of the First Amendment to the states. So that is, can the states interfere with your practice of a religion? And remember the Amish, they believe that their kids should have to stop going to school at age 14, but Wisconsin said no, they should have to go to 16. And the Amish said, well, you're violating our free exercise of our religion, right? And the Supreme Court ruled 7-0 in favor of Yoder and against the state of Wisconsin. And they didn't say that a state couldn't interfere with your practice of religion, but what they did say was that the state government has to provide a compelling government interest to interfere with the practice of religion. So the burden of proof is on the state to show that restricting the practice of one's religion is a compelling government interest. And in this case, the Supreme Court said no, the state did not meet that burden of proof that making students go to school was a greater interest than allowing people to practice their freedom of religion, okay? So that is the free exercise clause. Grand jury, not going to have to know that. Indictment, I don't think so. Libel and slander, I would draw a line between libel, slander, and symbolic speech because all 3 of those go together. Seditious speech as well. So I would draw a line between clear and present danger, libel, seditious speech, slander, and symbolic speech because those are all under the First Amendment. Remember, there's a broad spectrum of speech that we talked about. The most protected speech is pure speech, which is your opinion. And the least protected speech is slanderous or libelous speech, that is untruths written or spoken about another person. So I can't just go out saying lies or writing lies about somebody else and say that's freedom of speech, okay? That's not protected in the First Amendment. But I can have opinions about something or somebody else, and that's completely protected under the First Amendment. And then somewhere in between there is what we call symbolic speech. And remember, symbolic speech would be like, hey, I'm wearing this t-shirt, and clearly Cal Poly, by this t-shirt me wearing it, Cal Poly is the best school in the history of the United States. Okay, even if I didn't say it, this could be a form of speech, wearing this t-shirt, okay? So who remembers the court case that dealt with freedom of speech? Who remembers it? Who remembers it? This was the one we were going to simulate in class, but we didn't obviously get to do that. It's too bad because it's a really fun simulation. Remember Tinker v. Des Moines. So if you remember the Tinker v. Des Moines case, students were going to wear armbands to school in protest of the Vietnam War. And the school district of Des Moines, Iowa, had said any student that wears an armband to school will be suspended, and the students wore the armbands to school anyway, and they were suspended, and they sued the school saying their First Amendment freedom of speech rights were violated, right? Hoping all this rings a bell to you. These should be a bunch of oh yeahs, oh yeahs. I remember these. And so the court ruled 7-2 in favor of the Tinkers that the state or the school district representative of the state did not get to abolish a student's First Amendment rights while they were on campus. So you do get freedom of speech on campus. If you remember a couple years ago, we had a kid that wore a Confederate flag shirt on, or Confederate flag sweatshirt on campus, right? He's protected by the Tinker v. Des Moines case. The schools did not say that a school cannot stop forms of speech. What they did say is that the school would have to say that the speech would cause a material or substantial disruption to the school. Then they could limit the speech. But the schools could not proactively or preemptively limit a form of speech because they said it might lead to a disruption. If that happened, then we would then have school officials basically deciding what speech is allowed and what speech isn't allowed, trying to interpret the Constitution. So if somebody does speech like on campus, if you remember the bong hits for Jesus example, there was a student who was holding up signs at an assembly that said bong hits for Jesus. The school then had the right to then stop that student from speaking because that kind of speech was a material or substantial disruption to the school. So the school then reactively could stop that speech. Okay. And so Tinker versus Des Moines, again, incorporated the First Amendment freedom of speech to the states. Okay. So I'm going to get rid of these as I go through these. So I don't have to keep going on. Which one is this? We did Schenck versus US already. I'm going to close it out just so I don't have it up there already. Nope, haven't got to that one yet. Nope, we haven't got to that one yet. Nope, we haven't got to that one yet. Nope. Ingo Vital. Yep. Nope, haven't got to that one yet. Okay, so now let's come back to our review. Okay, freedom of the press, ladies and gentlemen. Oh, and by the way, seditious speech is advocating overthrowing the government. Okay, seditious speech is actually encouraging others to physically try to overthrow government officials. So remember, I can believe anything I want about the government. I can believe that the government is tyrannical and suppressing our rights. And I can say that we should try to replace the government. And that's totally protected under your opinion speech or pure speech by the First Amendment. I can blog all I want to, put podcasts all I want to about how the government's awful, they're tyrannical, they're limiting our rights, everything like that. That's fine. That's not seditious speech. That's just my opinion. Once I start encouraging others, hey, let's pick up these weapons and go kill government officials. Let's pick up these weapons and go try to overthrow the government. That's where the line gets drawn, and seditious speech is not protected under the First Amendment. Okay. All right. Now, freedom of the press. Again, what amendment, ladies and gentlemen? What amendment? What amendment? What amendment? That's right. The First Amendment. And who remembers the court case dealing with freedom of the press? Let me bring it up here. Here we go. New York Times versus US. So this was, again, incorporating freedom of the press, First Amendment to the states. And if you remember the whole, the basic story behind this was that a government employee of the United States had illegally obtained some documents about the Vietnam War and distributed those documents to the New York Times and the Washington Post. And the federal government tried to stop the New York Times and Washington Post from publishing these articles. And they tried to argue that because it was a matter of national security, that the government could then stop freedom of the press in that instance. And the court ruled 6-3 in favor of the New York Times. And remember, the key justification, what was the opinion they put out there, was that the government can actually limit freedom of speech if it's vital to national security. The government actually can use what's called prior restraint and stop a publication before it's given, but there is a heavy burden that the government must show in order to impose such a restraint. And in this case, the documents that were released to the New York Times and Washington Post were embarrassing about the government, but they weren't vital to national security. And so they argued that the leaking of these documents, while was embarrassing to the government, that didn't meet the burden that government needs to show in order to justify doing a prior restraint on that. And that's what prior restraint is. It's where the government actually tries to stop speech before it's been given in the first place. Okay, so freedom of the press. All right, now I'm going to close that one out too. Okay, let's come back to our packet here. Freedom to petition, the First Amendment, the Patriot Act. Some people would argue that the Patriot Act is a violation of our of our Fourth Amendment rights. The Patriot Act was passed just after September 11th, when the terrorist attacks on New York and the Pentagon in Washington, D.C. happened. The Patriot Act allowed government agencies to wiretap phones, to monitor bank accounts, monitor email accounts without actually serving them with a search warrant in the name of stopping terrorism. Okay. Now let's come back up here to due process a little bit. Well, let's come over to here. So one of the court cases that we haven't got to yet is Gideon versus Wainwright. Remember, due process of law is where if the government's going to take away your life, liberty, or property, that they have to follow due process of law. So what does that mean? Well, you have to have your rights read to you, so you're informed of your rights, called your Miranda rights. You have to be given your trial rights in the Sixth Amendment, right? So for example, you have to be given the right to a public trial, a jury trial, a bench trial, a speedy trial. You also get the right to confront witnesses, and from Gideon versus Wainwright in the Sixth Amendment, a part of due process is, let's go up to Gideon versus Wainwright here if I can find it. Gideon versus Wainwright incorporated the Sixth Amendment's right to counsel. If you remember the basic facts of the Gideon case, Gideon was convicted of basically burglary by the state of Florida. He asked for an attorney at his trial. The state of Florida denied him attorney. And when he was in jail from a Florida state prison, he wrote just on prison stationery to the federal court that his Sixth Amendment rights had been violated. Now remember, Gideon was wrong. The state of Florida did have the right to put somebody in jail without an attorney because the Sixth Amendment had not been incorporated yet. The right to counsel on the Sixth Amendment only applied to who? To the federal government, right? In Gideon versus Wainwright, they incorporated the Sixth Amendment right to counsel to the states. And so after Gideon, that is why now if any state government wants to take away your life, liberty, or property from you, or take away your freedom, the state government has to provide you counsel if you cannot provide counsel to yourself. So before this, the federal government or the state government could put you on trial without an attorney. Now, certain states did put it in their own Bill of Rights that you had the right to counsel if the state tried to put you in there, but not all states did. For example, Florida did not. So after Gideon, the Sixth Amendment was now incorporated, and all states have to now give you the right to counsel. Okay, so that's a part of due process as well. All right, come back up here. Let's come back to here. All right, what's the next one? Brown versus Board of Education. Now let's stick with civil liberties. Let's come down. Let's go to Roe versus Wade, okay? Roe versus Wade, ladies and gentlemen. Here we go. I think that's it right there. So Roe versus Wade, ladies and gentlemen. Remember, it comes from which amendment? The 9th Amendment. So what is Roe versus Wade? Everybody thinks this is an abortion case. And legally speaking, it's not about abortion. Think to yourself, what was Roe versus Wade legally about? And remember, it's about your right to privacy. So if you remember the 9th Amendment was one of the concerns put out there by the Federalists. It addressed the concerns of the Federalists. Remember, one of the reasons the Federalists, who were in favor of passing the Constitution, didn't want to list a Bill of Rights is they were afraid if they put a Bill of Rights in there, that people would interpret those Bill of Rights as the only rights that you possess from the federal government, or liberties from the federal government. And so the 9th Amendment are your unlisted liberties. So the 9th Amendment are your unenumerated liberties that if we forgot to list any liberties, that doesn't mean they don't exist. For example, your right to privacy. And so in Roe versus Wade, the Supreme Court incorporated the 9th Amendment's right to privacy to these state levels. Now, what does that mean? It means that a woman has the right to privacy over her body, and she has the right to have an abortion. Now, they laid out some first trimester, second trimester, third trimester, and this case has been, there's been multiple cases since then, like Planned Parenthood versus Casey. And so there's been many other cases about what a state can and cannot do as far as restrictions go on a woman's right to an abortion. Even to this day, there's cases that reach the Supreme Court on this. But keep in mind that Roe versus Wade, it is the one that legalized abortion, but legally, how did abortion become available to women at all states? It's because of women's right to privacy through the 9th Amendment. So remember, before Roe versus Wade, some states allowed abortions and other states didn't. It was a state-by-state issue. And so after Roe versus Wade, it said all states cannot deny a woman right to an abortion. Okay. And so that's privacy rights from the Ninth Amendment. Okay. And keep in mind that the Ninth Amendment was a way that the framers of the Constitution, especially Federalists, were addressing their concerns that some people would want to limit our rights if we listed a Bill of Rights. Okay. All right, let's come back to this up here. More court cases here. All right, let's come down to McDonald v. Chicago. Okay, let's remember this, McDonald v. Chicago. I'm skipping back around again. And by the way, you need to have all these printed out, ladies and gentlemen. All of these court cases, all of these need to be printed out. You should have all of these already in your Google Drive, saved in your court case folder that we made. Remember that handy little thing? You need to have all these printed out, okay? You could also have this one printed out too. This is from the review packet. Okay, this is a court case summary of all the cases that we have with just but this doesn't have all this is just a quick summary of it, ladies and gentlemen. So this would be like, I already know the court cases and I just want a quick review. Oh yeah, Roe versus Wade. Oh yeah, Gideon versus Wainwright. Oh yeah, Wisconsin versus Yoder. Okay, did I just say yogurt? Wisconsin versus Yoder. So I wouldn't recommend using this as your reference unless you've already studied the court cases. This is not going to help you write an FRQ unless you've actually studied the court cases. This would be a good reminder. Okay, so McDonald v. Chicago, this was in 2010, I believe, incorporated the Second Amendment right to bear arms to local and state governments. So if you remember the city of Chicago, they had passed some handgun restrictions, and these handgun restrictions made it almost impossible to own a handgun, and the city was sued saying that they were taking away life, liberty, property without due process of law. And in a narrow 5-4 decision, the Supreme Court ruled that the Second Amendment doesn't apply to local and state governments, not just the federal government. Okay. Interestingly enough, there's been a recent case in New York of where New York had a law that basically didn't allow people to transport their own gun from one residence to another, even if it was a legally owned gun. In that case, made it to the Supreme Court, but by the time it made it to the Supreme Court, the city had repealed the gun law, and so the Supreme Court dropped the case. I want to remind you that sometimes the Supreme Court, when a hot potato issue comes up like that, they'll sometimes just kick it back to the lower court, or they'll find some reason to get rid of it. This was one of those reasons. There were actually 3 members of the Supreme Court that disagreed with the decision of the Supreme Court to drop the case because the city of New York had dropped the law. They said, no, this is an issue that needs to be addressed. But there we go. All right, so McDonald v. Chicago. Get off of there. There we go. All right. Now, let's come back up to our civil liberties, our civil rights, again, court cases here. So let's start with Brown versus Board of Education, ladies and gentlemen. I already did the letter from Birmingham Jail. Last court case here, Brown versus Board of Education. I like this case because it's several things. It talks about the Supreme Court. It also shows why Supreme Court justices write opinions. This one and Gideon, I think, are good examples of why Supreme Court justices write dissenting opinions. So for those of you that haven't watched the judicial branch lectures yet, which means at this point most of you, whenever the Supreme Court issues a decision, they write an opinion. Now there's a majority opinion, which is the one that sets the legal precedent, and that is the law from here on out. But then there are dissenting opinions of where the judges disagree with what the Supreme Court ruled. Remember, the Supreme Court has overturned itself almost 200 times, and this is one of those cases. Remember, Brown versus Board of Education was about, hold on, let me get a drink of water here. Brown versus Board of Education was whether or not segregated schools by race were allowed under the Equal Protection Clause of the 14th Amendment. That is, if states did practice segregated schools, but they were equal facilities, should that be allowed under the Equal Protection Clause? And remember, in Plessy versus Ferguson, the Supreme Court had ruled, yes, segregated schools are legal as long as they are equal. So that was called the separate but equal case, right? And then 60 years later, the Supreme Court reversed itself and they said, no, that's a violation of the 14th Amendment's Equal Protection Clause. And this is a good reason of why many judges write dissenting opinions. Even though dissenting opinions from the judicial branch carry no legal precedent, many times those dissenting opinions will be used as the majority opinion to overturn a previous ruled on case. For example, in Gideon versus Wainwright, Betts versus Brady had said the states don't have to give you the right to counsel when they put you on trial. Justice Hugo Black had wrote the dissenting opinion from Gideon versus Wainwright. And Justice Hugo Black then basically used his dissenting opinion from Betts versus Brady to become the 9-0 unanimous decision in Gideon versus Wainwright. All right, so there we go. That's Brown versus Board of Education, ladies and gentlemen. So this incorporated the Equal Protection Clause, 14th Amendment, that that students have to be treated equally under state law in this integrated schools in the South. Okay, let's come back to this up here now. So I've gone over all these court cases. I've gone over all these. Let me see. I go over these questions here. Key court cases. We did this. Title II, Title VII, Title IX. I went over this. Commerce Clause is linked to Title II. I went over that already. I already did the First Amendment. I did all these. The impact of the corporation doctrine. The First Amendment, the court case, we just went over that. All the court cases, Schenck versus U.S., Wisconsin versus Yoder, Ingle v. Vital. The Second Amendment, McDonald, I need to put that on there. Well, I can't. McDonald versus Chicago incorporated that. The Sixth Amendment, Gideon versus Wainwright incorporated that. So if you were going to get an argumentative essay from this unit, I could see them being an incorporation doctrine, and I could see them having primary documents like court cases and the Constitution. And so if they were going to say the Constitution as a primary document, you would say the 14th Amendment from the either Equal Protection Clause or the Due Process Clause of the 14th Amendment. Okay. Okay, so I've gone over that. That's Unit 2, ladies and gentlemen. Again, there is this court case summary here. Let me make this a lot smaller so you can see it. But I don't recommend studying from this. I recommend you study from the court cases that we filled out the graphic organizer from, and then having this printed out right here just as a quick review. So when you're writing, because you're not going to have time to go look up the court cases. You're not. Okay, I'm going to talk more about what the time's going to be like. But if you don't know this going into the test, you're not going to have time to look it up and then write a coherent thought and put it together. You're not. So the key thing here is that know these cases. What do you not have to know, ladies and gentlemen? You don't have to know Citizens United versus FEC. That's off the table because campaign finance cases are not in there. But all the rest, these are all fair game. Okay. All right. Let me stop screen sharing there. Okay, so that's Unit 2, ladies and gentlemen. I'll be posting 3 more videos before the AP test. One on Congress and the President, another one on judicial branch and bureaucracy, and then I'm going to post one more video on the process of the day you take the test, so you can kind of just take a look at what that's going to be. That's only going to be about maybe a 5 or 10 minute video. Again, I hope everybody's doing well. Please email me, email each other, text. You don't email each other. Snapchat each other, whatever you guys do, Instagram each other, get everybody to watch these videos, ladies and gentlemen. The AP test is coming up May 11th. I want you to pass because I want you to have something you can take away from your senior year. Okay. And then after the AP test, I have decided I am going to post some personal finance videos on YouTube just for you to look at. Because I know a lot of you were looking forward to the personal finance unit that I was going to do. So I will be posting those. I don't know how good they're going to be because, it's just like this. But there we go. All right. Everybody take care, and I hope everybody's doing well. All right. Bye.